A growing number of Republican-led states are modeling new abortion bills after the new law in Texas. That Texas legislation bans the procedure once a fetal heartbeat is detected. That's usually around 6 weeks of pregnancy before many women even know that they are pregnant. On Thursday, Oklahoma Governor Kevin Stitt held a ceremonial bill signing for a series of anti-abortion laws similar to those in Texas. The measures take effect on November 1st. For more on this, I want to bring in David Noll. David is a professor of law at Rutgers Law School. David, how much does this Texas law and the Supreme Court's decision not to weigh in affect abortion access in other states, and how are these bills able to get around our understanding of Roe v. Wade?
So under long-established Supreme Court precedent, states can regulate abortion after a fetus is viable, but pre-viability abortion bans are unconstitutional. And we're already seeing that these laws are having a major effect on the ground. Abortion clinics in Texas have reported that they are dramatically cutting back on the services that they're providing because of the threat of lawsuits under laws like SB 8. And the way they're able to do this is by manipulating the way that the abortion ban is enforced. I have to explain a little bit of the legal context to make this make sense. But usually when a doctor or an abortion clinic or someone like that wants to challenge a state's abortion law, the way you do that is you file suit against the state official who's responsible for enforcing the law, say the Department of Health or the Attorney General. What Texas did in SB 8 is it said state officials can't enforce the law. And instead, in the words of the law, any person is given the right to file a lawsuit against a doctor who performs an abortion, and indeed against anyone who aids or abets the performance of an abortion or anyone who intends to do so. And so by relying on private parties to enforce the law, SB 8 effectively shuts off abortion clinics' ability to challenge the law before it's enforced. Instead, doctors have to wait to be sued in state court. And because of a quirk of federal court jurisdiction, the cases can't even be removed to the federal courts, so they have to be heard in Texas state court. So
you brought up that part of the aspect of this is allowing for individuals to bring these lawsuits. And one of the most controversial aspects of the Texas law is, in fact, that it relies on these private citizens for enforcement. The public can now sue the abortion providers over alleged violations, but they can also sue anybody else who was even remotely related, including somebody who drove someone to a facility. Is this unprecedented?
It's really quite an extraordinary enforcement scheme. It's almost as if the state enacted a law that prohibited robbery. But then instead of saying that that would be enforced by your local district attorney, the state said that suits can be filed by anybody in any court in the state. And you can see how easily that can be abused, right? Even if we all think that robbery is bad, giving everybody the right to file suit is almost an invitation to abuse. And, that's part of what this law is doing. And the clearest evidence of that is that it bars courts from awarding attorney's fees to the defendant, even if a case is frivolous, even if it's brought in bad faith as a way of harassing the defendant.
So the defendant then would not be able to recover the lawsuits the money that they had to spend to defend themselves, essentially bankrupting anybody put in that position. I want to touch more on the private surveillance aspect, because not only does it allow for these lawsuits, but that there's a financial incentive, a reward given to people who report on other people. You have a recent paper explaining how the Texas measure is part of a wave of what you call rights-suppressing laws. Explain to our viewers what you mean by this and why the impact is so significant.
So yes, a paper I wrote with John Michaels at UCLA. The idea is that what these laws are trying to do is suppress other citizens' exercise of their rights, generally their constitutional rights. And they do that through procedural provisions that are essentially stacked in favor of the plaintiffs. So as you mentioned, if you file a lawsuit to enforce SB 8 in Texas, and you prevail in that, you get your attorney's fees, so you don't have to pay for an attorney, which is oftentimes the most expensive aspect of being involved in a lawsuit. You get a minimum of $10,000 in damages. You get your legal costs. You get the ability to file suit wherever you want in Texas, and the law specifically bars defendants from asking courts to move the case to a more convenient venue. It's really difficult to locate a historical precedent for this. There's, of course, laws that environmental laws, consumer laws that are enforced through private litigation, but they don't have these broad standing requirements. And they also don't set up plaintiffs to essentially act as bounty hunters or as vigilantes who are taking on the enforcement of state law.
Well, we know that the Justice Department does not feel like this case is settled yet. David Noll, thank you.
My pleasure.